please be seated? All right, welcome to the 14th Court of Appeals today. We have one argument on the docket, Qualia Labs, Inc. versus Stewart Title Company. 15 minutes per side. Do you wish to save time for rebuttal?
Yes, Justice. I have reserved 5 minutes.
Okay. All right, well, we are ready when you are, so you may proceed.
Thank you, Your Honors. May it please the Court, Kristen Jones here on behalf of Appellant Qualia Labs here today. I have, as I said, reserved 5 minutes for rebuttal argument. And we are here today on a matter concerning a software licensing agreement and the interpretation of that agreement as it primarily relates to an arbitration provision contained within it. But while I'm up here as the appellant today, we are here actually on an interesting procedural posture because, as you all know, this court, and in fact this panel, has already reversed the one of the interlocutory orders that was signed by the trial court in this matter, and reversed the trial court's order granting Stewart's motion to stay and enjoin the arbitration, and have remanded this case back. And while I am very happy to stand up here and explain why your original order was 100% correct, which it is, I would like to start with addressing, Your Honors have issued the letter addressing Stewart's proposition that that order has to be withdrawn, and respectfully, that is incorrect. So Stewart has pointed you to the case of ERCOT versus Panda Power from the Texas Supreme Court from 2021, and to support their proposition that that order needs to be withdrawn. This court's prior opinion needs to be withdrawn. But indeed, just a year later, after the Panda Power Fund's case was issued, the Texas Supreme Court in 2022 issued its case in Chen versus Raspberry Techs, and this has been cited to you in the reply briefing. And that actually said, expressly rejected the same argument that Stewart has made in its briefing to this court. And it said that the Texas Supreme Court clarified that when an interlocutory order is published after the entry of final judgment, as we have in this case, that interlocutory appeal remained a live controversy and is treated as an appeal from the final judgment. And the distinction
between... But was there a separate appeal in that case? Here we have the appeal from the interlocutory order and an appeal from the final judgment.
We do, and in Chen, they did not have a separate second final appeal from the final judgment. And if Your Honors look at the appellate briefing, this is interesting because our arbitration order, what I've described as the arbitration order versus the abatement order, it's really two sides of the same coin. But in order for us to make sure, out of an abundance of caution, that we have preserved that error, we did pursue an appeal on the final judgment. But what Chen very explicitly makes clear is that when you have an interlocutory order, or an interlocutory appeal that's pending while a final judgment is issued, that appeal remains a live controversy. It's just considered an appeal from the final judgment.
But that would make sense if there wasn't a notice of appeal filed after the final judgment was signed. I mean, because otherwise you'd be taking away the parties, you'd be impairing the parties' appellate rights if you were to dismiss the interlocutory appeal in Chen. You understand what I'm saying? In Chen, if there's an interlocutory appeal that's pending, but and then a final judgment occurs and there's no further notice of appeal after the final judgment, it would make sense for a court to treat the pending appeal as an appeal from the final judgment.
Right.
Otherwise, the appealing party's rights are going to be completely vitiated.
Well, if my reading of Chen is that it clarified that they controversy, but it actually said that if they had wanted to appeal from another issue within the final judgment, which in Chen they did not, that they would have needed to file another notice of appeal of that final judgment, and that's exactly what we did here. Because as you know, there were not only 3 interlocutory orders that were signed, but then we had a final judgment that included an almost $400,000 fee award that was attached to the final judgment that was issued before this court issued its interlocutory order.
All right, so let's say we agreed with you and rejected Stuart Title's argument in the motion for hearing. What do you think should happen?
So I think
in our case, in the appeal from the final judgment.
The appeal from the final judgment. So in our motion for rehearing, we proposed that, and again, this court has jurisdiction over now not only the final judgment but also the interlocutory appeal, certainly. So we propose that this court simply vacate and vacate all of the, not only the final judgment but the other interlocutory orders, and instruct the trial court to do exactly what you have already instructed it to do, which is to abate or stay the trial court proceeding in favor of the arbitration.
If we do that in this appeal, why does it hurt you to withdraw the opinion from the earlier appeal?
Well, because we won. It is now, in our opinion, it is now, well, not in our opinion, the law says this is now law of the case. Your honors have already decided the threshold issue of arbitrability, and so pursuant to your order, all of the subsequent orders that the trial court issued were, she was without jurisdiction to sign those orders. And so it's just a matter of unwinding. To answer your question directly, procedurally, whether or not the initial opinion in the interlocutory appeal is simply adopted in this case, I don't know if there's a technical distinction between that at this point, especially with now that we're before you in this the second proceeding of the final judgment. I'm not sure. It might be a distinction without a difference of whether or not you issue the remand in order to vacate the other judgments in the prior appeal or in this appeal. But regardless, I think even Stuart would agree that if the opinion of the interlocutory order stands, then all of the other orders that the trial court issued have to be vacated and unwound in order for the question of arbitrability to be decided by the arbitration panel, which is what the parties agreed to. So there aren't any more questions on the Chen versus Panda Power Funds. I'm happy to discuss the merits of the arbitrability question. I, again, think that the opinion of this court was already very properly decided, but I have a couple issues I'd like to raise that were raised in their rehearing briefing. Particularly, they tried to make Stuart tries to make a distinction regarding the language of that our agreement says that our agreement says that we should be using the AAA rules as opposed to in Total Energies. They said that they have to proceed in accordance with the AAA rules, and they have not cited any support for this distinction that the term using is different than accordance with. But I would argue that the only case that they did reference refers to this just passing reference in as to using of the AAA rules, and the term using is not just a passing reference. It certainly evokes action, and that the parties are meant to use the AAA rules. They also made an argument that there is no arbitrability decision for the panel to decide, and respectfully, again, that is simply incorrect. both 13.1.3, which is under the dispute resolution provision in our agreement, has qualifying language, as does 13.3, which is the remedies provision. It is in the event that of a breach of Section 10, any infringement or misappropriation, or when injunctive relief is the only appropriate remedy or appropriate relief. Again, whether or not those apply are exactly what the arbitration panel will have to decide. And same thing with 13.3. It says in the event of two specific events of when an injunction would be appropriate. I'll continue after.
All right, we'll hear from you again on rebuttal. Mr. Garcia.
Yes, Your Honor. Roland Garcia here on behalf of the Appalachia Stewart Title Company. We think Your Honor asked the correct question. The difference in Chen versus the ERCOT versus Panda case was that in Chen there was no appeal of the underlying merits. So it makes perfect sense then instead of two appeals, what happens is those can merge because you have this same issue of arbitrability is also in the second appeal. There's a confusion, I think, between the issue of procedural mootness and substantive mootness. We're not arguing that the arbitrability issue is substantively moot. It's being addressed here, was fully briefed by the parties in this case. It can be addressed here. It would be most efficient to do that. We want to point out a case that is a recent case out of the Austin Court of Appeals in Henderson versus Amherst and Brown. It's 2025 Westlaw 97687. The court there basically noted that there was an interlocutory appeal of an order, that the appellant there was a vexatious litigant, and the court said it became procedurally moot after there was an entry of a final judgment. But, like in this case, there was also a pending of an appeal on the merits. And so therefore the issue underlying was not substantively moot. And so what the court there said was that because the briefing was complete, the efficient thing to do was that the interlocutory order merged into the final judgment that was the subject of the second appeal. We think that is...
So the Court of Appeals dismissed the interlocutory appeal?
Yes, Your Honor.
Okay.
They may have used the word merged into it, as I recall, but we think that is procedurally the way to go. It's the efficient way to go. It's, I don't think, appropriate to vacate orders in the second appeal which were not briefed in part of the first appeal regarding merits, and I don't think that can legally be accomplished. On the issue of arbitrability, which is the big issue in this case, there are 49 cases, according to Westlaw, as of that have interpreted Total Energy's case. It's a fairly new case. And none of those cases have the exact same facts that we have in this case. We've tried to show Your Honors why we believe that our case is a different contract language than what is in the Total Energy's case. And what we're pointing out here is that this is the perfect record for Your Honors to decide what does it mean when the Texas Supreme Court says the parties are free to limit their arbitration delegation to limit it to certain claims and controversies. We believe that's exactly what these parties did here, was they negotiated at arm's length to limit the arbitration delegation by number one, multiple ways. One way that they did it, Your Honor, was that, and first off, let me back up to say, I want to point out that Total Energies even itself makes very clear that the general rule and the presumption is that it is the court to determine arbitrability unless there's a clear and unmistakable intent to delegate that to the arbitrator. That's at page 702 of the Total Energies. It's also paid in the Jody James case. We believe Total Energies is a very limited holding that's been vastly expanded by, attempted to be expanded in this case here. And we believe that the issues of scope and the issues of the delegation are to be looked at separately. That's two pieces of this case. What is the scope? And then what is the delegation provision? Qualia wants to argue that you expand the arbitration clause to be the entire contract, and that's not the case. What we have here is that the parties expressly limited their delegation in two ways, and that's allowed in page 712 of the Total Energies case. First, they included sections 13.1.3 and 13.3 outside the arbitration provision. It's not in the arbitration provision. Second, they make very clear in the scope of the arbitration clause, which is in 13.1.2, in the scope it says, quote, except as provided in section 13.1.3, neither party will invoke formal dispute resolution, etc. That's a limitation of the scope of what's to be arbitrated.
Where is that again that you were just quoting?
It is in, if you, I have an exhibit A, I don't know if your honors have that.
I have it, I'm looking at it.
It's on page 73 of the record at the bottom, and it's at 13.1.1 in the middle at the top, the first highlighted words,
Okay.
It says except as provided. That's what we call a limitation on the scope of the arbitration clause. Parties are free to do that. Total Energy says you can do that in page 712 of that opinion. Then, in addition to limitation of the scope, they limited the delegation, which is the uses of the AAA rules. The delegation is only by virtue of using the AAA rules for arbitration. But as we saw, that's carved out. That is not even part of the scope. And what the parties then did was, and if you notice, they added a separate provision, which is 13.1.3, and they even made it double clear that notwithstanding anything else here in the contract, either party may seek the appropriate injunctive or other equitable relief at any time when the injunctive relief is the only appropriate relief. That's exactly the scenario that was contemplated by the parties. When Stewart Title Company spent millions of dollars to purchase the software from Qualia, actually from the predecessor, Adeptive, they put it all across their entire business platform. They continue to pay maintenance to use it. And then what happens is Adeptive gets bought by Qualia, and Qualia decides, you know, we want you to pay millions more to use what you've already paid millions to use. That was a complete inappropriate and wrongful act under this contract. We pointed that out. Qualia only has the right, Your Honors, to terminate this contract under section 9.1. And 9.1 only gives Qualia the right to do that for cause. Even if Stewart Title had breached, they need to send us the letter that you're being terminated for cause, and then we have a right to cure. None of that happened because they know there was no breach by Stewart Title. They just wanted more money. And so Stewart Title, we tried to negotiate with them, Your Honors. It's in the record, so I'll elaborate on the facts. And we met, we exchanged briefs, letters, and couldn't resolve the matter. And so Qualia said, you've got until July 2024, and this is going to terminate. That would have been incalculable damages. They say, well, there's no evidence of irreparable harm. It's in Brad Rabel's declaration, which is Exhibit B to this proceeding, Your Honors, that we made very clear what the irreparable harm would be. We set out specific facts. how the company cannot operate without the software, that it would take much longer, years longer than July of 2024 to transition to a new piece of software. They gave no factual basis to terminate. They continued to insist that they were going to turn off the software. So we had no choice but to invoke 13.1.3 and 13.3 to go maintain the status quo.
In your argument under 13.1.3 was that there was a breach of section 10 or an infringement, or just that there was injunctive relief was the only appropriate relief?
Correct.
All of
based
it?
on based on the quote, when injunctive relief is the only appropriate relief.
Okay.
Close quote. We're not arguing breach of the other sections, but
okay.
that it was to allow us to continue to use the software, which was bargained for by the parties. So our position, Your Honors, is that on that, and I've only got 5 minutes left, was that there was a limitation. It was separated, and I think Qualia wants to have it reversed, that the general rule doesn't apply, that everything is subject to arbitration unless there's a litigation carve-out. It's the other way around. Unless there's a provision that expressly says that the arbitrator is to decide the dispute, or you delegate it to the arbitrator for arbitrability. Short of that, it's for the courts to decide. So our position is this: if you look at 13.1.3 and you look at 13.3, there's no mention of arbitration in there. There's no delegation to the arbitrator for arbitrability. That's only up above in the arbitration clause, which is separate. And the Texas Supreme Court has said, under the concept of severability, you look at the arbitration clause separate and distinct from the contract as a whole. And so that is at page 709. It kind of gets missed in this discussion, but that's an important provision that supports our arguments here, Your Honor. And so we are arguing that under the rules of contract construction, and then you have to consider the word notwithstanding. Well, Qualia doesn't even want to talk about what that word means, notwithstanding. Parties are free to contract. All words are to be given meaning, unless, failing that, then the parties cannot rewrite the contract. Qualia would want to rewrite and take out the word notwithstanding. Qualia would want to rewrite and take out the words, quote, except as provided in section 13.1.3. Qualia wants to rewrite and put in an arbitration language and an arbitration delegation in 13.1.3 and 13.3, but it's not there, Your Honors. There are other things Qualia wants to rewrite, and that takes me now to the issue of the summary judgment on the merits. If Your Honors decide that it was proper for the court to rule this, which we believe that was the case, Your Honors, they're challenging the summary judgment underlying it. Qualia wants to rewrite that section, that part of the contract. If you look at the contract on section 2.1, which is at the record page 59 in the exhibit you have, Your Honors, it's very clear here that this software license was a grant by Adeptive to Stewart Title for a, quote, worldwide, non-exclusive, non-concurrent, non-transferable, irrevocable, and perpetual license to use the software, close quote. Qualia wants to rewrite that to say, well, that doesn't mean what it says, just like they're arguing everything else doesn't mean what it says. It means exactly what it says, and we cited two cases, Nano Proprietary and the Provider Meds case, which both talk about when you use words like irrevocable and perpetual, they mean what they say, and you have to honor that because it was bargained for. The case that Qualia cites is a case which did not have a definite term of duration, and under the statute they cite, we concede if there's no term of duration, as we have in section 2.1, well then possibly under the facts that contract could be considered indefinite, and therefore under a certain scenario a party may say, you know, after a reasonable period of time I don't want to do business with you anymore. And that concept is illustrated in a really good case that actually supports the scenario here, and that is the case called Leaders and Fluorogas. In that case, what the court explained there is it was a license agreement similar to what we have here, but it was a non-exclusive license similar to what we have here. And the court noted that the non-exclusive use of the technology being licensed, quote, does not impose any obligations on the licensor for an indefinite period of time, period, close quote. That's the Fluorogas case at page 857. Exactly the facts what we have here. We're not asking Qualia to do anything for us. We purchase the software, it's installed on the machines, people are working. If there were like ongoing obligations and there was a fallout and they wanted to terminate and there was no clause for a term of duration, I could see their argument. That's not what we have here. They want to rewrite this. They want a second bite at the apple. The court correctly granted summary judgment. And by the way, there were no fact disputes on the issues of irreparable harm or imminent harm. They point to the fact that the affidavit they say was just conclusory, but that's Exhibit B, and we highlighted it for your honors to show there's abundant facts in there that shows the imminent harm and irreparable harm. And we just are asking that the summary judgment be upheld. There was no fact challenge to the fee motion either. No controverting affidavit that any of the time was unreasonable or quibbling about time entries. They didn't even argue that my rate was too high. Nothing. They just argued that certain categories of fees were should have been carved out. The judge agreed with them and carved those categories out. But otherwise, the fee award was not challenged. We think as a matter of law, the court's ruling should be affirmed.
All right. Thank you, counsel. Jones, you have 5 minutes.
Thank you, Your Honors. If I may address a couple points right off the bat. Mr. Garcia said that the difference between Panda Power Funds and Chen was that there was a subsequent appeal from the final judgment, but that is not the distinguishing factor between Panda Power Funds and Chen. The distinguishing factor was in Panda Power Funds, there was an interlocutory order that was signed before the final judgment was signed. Okay, so the interlocutory order came down, and then days later the final judgment was signed, and then there was an appeal from that, and that is this scenario of Panda Power Funds. That is not what happened in Chen. There, the interlocutory appellate order came in after the final judgment was signed, which is exactly what we have here. And again, we certainly do not dispute that the arbitration order and the abatement order are two sides of the same coin, and those issues are before you, but we certainly believe that the prior order entered by this court is controlling now law of the case, and that because of that ruling, all of the other rulings and orders have to be unwound and vacated, whether in that matter or here in this matter. There were a couple of comments regarding the argument of the notwithstanding language, and I understand their argument to be that this isn't a carve-out, it's a standalone provision, but I asked this court to look that provision is very specifically underneath the 13.1 dispute resolution provision. right? So it has then 3 subsections, and it is 3.1.1 that requires an informal dispute resolution process, which these parties did. Okay, so they complied with the 13.1.1 of the informal dispute resolution proceeding that was earlier described to you by counsel. Then 13.1.2 is the mandatory arbitration clause that requires use of the AAA rules, and that is we're not trying to flip it on its head. It's the AAA rules that say that it is for the arbitrators to decide scope and scope. Oops, I lost my place. The scope, validity, or the arbitrability of any claim. That's 13.1.2, and then it's 13.1.3 that says, notwithstanding, then there are certain events when injunctive relief may be appropriate. The issue is there is a dispute, and the term dispute is defined as a dispute regarding the performance, interpretation, application, breach, or claim under this agreement. There is clearly a dispute of whether or not the issues presented by Stewart in this matter fall under this provision. We wouldn't be here if there wasn't a dispute, and under these provisions, those disputes must go before the arbitration panel to determine arbitrability first.
Well, why doesn't 13.1.3 allow them to go to the court for injunctive relief?
Well, so the question of, and he said that the only provision they're going under with 13.1.3 is the 3rd section of when injunctive relief is the only appropriate relief. Injunctive relief, as your honors know, requires very specific showings of proof, and they filed their summary judgment and their motions 9 days after we had answered this case. We hadn't conducted any discovery or anything, again, because we needed this to go to arbitration. But the question of when injunctive relief is the only appropriate relief, to determine whether or not that applies here, that's for the arbitration panel to decide. So they can't, and really, your honor, to bring this all into perspective is that if Stewart is permitted to unilaterally declare, right, they've come in and they've said, well, this situation is when injunctive relief is the only appropriate relief. They get to say that, and then we don't have the ability to contest it or challenge it or to have the arbitration.
Well, they would have to prove it, and then one of the things they'd have to prove is a probable recovery of the rates. Okay, so they would have to prove a right to injunctive relief, correct? If they wanted to invoke this provision.
Not only prove injunctive relief, but that it was the only appropriate relief, which interestingly, also recall in this case, not only do they have injunctive relief, but they also got declaratory relief. So the question of whether or not this was the only appropriate relief, when they also got other relief, again, begs the question that should have been answered by the arbitration panel.
All right, thank you, counsel. The case of Qualia Labs versus Stewart Title Company is submitted. Thank you for your arguments today. The court's adjourned and you're excused.
All right.